All right, got the keys going this morning. How's everybody doing tonight? Today. My name is 12 Gauge. Welcome to my channel. I am your host. I hope everybody's doing all right on this Saturday afternoon. Myself, I just finished some schoolwork, so things are going very well for me today. Thank you so much for spending some time with me today. Let me go ahead and put on the banner what I'm going to be talking about. If you haven't had any kind of exposure to this case, she was a University of Georgia medical student going into nursing. And her life was cut short due to a very selfish individual. It is terrible that this happened. Hey, Christy, thank you for being here. I did the first part this morning, so if you want to catch up later on the first part, that'll kind of lead you into this part. I'm going to go ahead and play the rest of the court opening statements. This happened about a year ago. She was a nursing student. She had gone to the University of Georgia, and she was murdered off a running trail while jogging on her morning run. So let me go ahead and start the video. And like I said, this is about halfway through, and then I'll put some other videos up here to give the people some insight on this case. It is just tragic to say the least. He's not even in the country. He wasn't even in the country legally. So he had committed this type of offense where he was from. I think he was from Venezuela.
So what other forensic evidence? The parties will stipulate to the prior court hearing that this court has heard, so we will not be recalling the fingerprint evidence, but we will have a stipulation with the transcript and all of the exhibits that thumbprint, that latent print that was on the phone was sent to ACCPD that night. And eventually, the digital image of that thumbprint on Laken Riley's phone was compared to Diego Ibarra, Argenis Ibarra, Rosbelli, and Juan Carlos, and they were all excluded. They didn't leave that thumbprint behind. And it was matched to this defendant, Jose Ibarra. It is Jose Ibarra's left thumb on Laken Riley's phone. And the analyst or the expert who did that analysis testified at the Daubert hearing. He showed the court 15 points of comparison that he found, and his results were peer-reviewed by another examiner, peer-reviewed blind, and she agreed with him. There's also DNA in this case, and you're going to hear about 3 different types of DNA: traditional, YSTR, and true allele. All true allele is probabilistic genotyping, but it is a computer software program that deconvolutes or separates complex mixtures of DNA. That's what.
Oh, wow, that's interesting. I've never heard of that. True allele. It separates DNA off jackets, gloves, fingernails, straws, hat. Wow. There's the traditional jackets, rocks, tree, YSTR off the fingernails. But the true allele sounds really interesting.
True allele does. But before you can go to true allele, you have to start with traditional DNA. So all of the items of evidence that you're going to hear DNA results from started with the traditional DNA. They were swabbed, they were amplified, they were quantified, all the things that you do with regular DNA. But we do have some regular DNA results in this case. First and foremost, the jacket. The jacket found in the dumpster has blood on it. And in the blood for traditional DNA, is Laken Riley's DNA and this defendant's DNA, and only the two of them. Jose Ibarra and Laken Riley's blood are on the jacket that he dumped in the dumpster. The rocks and the trees from the crime scene, they were also processed for DNA, for latent prints.
I don't know about you. Parts of this opening statement are giving me chills. It's really chilling what this prosecutor is laying out, this horrific story of the death of Laken Riley. She's doing an outstanding job, might I just say that too. I'm going to bring in our legal analyst guest now, watching remotely with us, criminal defense attorney and former prosecutor Franz Borghardt. Franz, your thoughts watching this?
Well, you know, we were wondering why waive a jury. That was kind of the question that we've been talking about all week. And, you know, hearing this opening statement.
And that's another thing. If you've never heard of trial by judge, this is what's going on with this. And by waiving that, I guess he got rid of the possibility of the death penalty. Because if he would have went before a jury, he would have had the death penalty on the table. So I guess waiving his trial by jury to judge, it took the death penalty off the table.
It's patently obvious. You know, the hope is that the judge can put some of the feeling and the emotion to the side and just look at what appears to be overwhelmingly strong evidence. So as gruesome as this is, it makes a little bit more sense in my mind why he may have chosen to waive a jury. So ultimately, I think it's going to have the same end result.
Right. And when you're before a jury, you know, you're convincing 12 or 6, depending upon, you know, the state you're in, as you know, Franz, and emotions can really run high, right? Because these are people who are good, upstanding citizens who may not have experience working in the criminal justice system and seeing, you know, horrific tragedies like criminal judges see day in and day out. And so being able to kind of separate from that emotion, I see what you're saying and why it may be advantageous to go judge, thinking that the judge is going to just look at the facts and not put any emotionality into the decision. The jury shouldn't either, but easier said than done. Tell me, when we think about the pieces of evidence she's putting forward, we're learning new pieces of information that were not, you know, part of the affidavit and made public. Tell me, has there been anything that's really jumped out to you as, oh my gosh, they have this evidence?
Well, you know, it was always a strong case, but for me, the DNA is always going to be a subtle burden shifter, Julie. And by that, I mean, the defense doesn't have any kind of burden to put on any kind of presentation or case. But when all of a sudden we have DNA in a place where it's not supposed to be, then if I'm a juror or a judge, I'm looking at the defense and saying, hey, what's that about? How are you going to explain that? And if you can't explain that, it's like the Titanic going down. It's just going to keep sinking from there. So for me, what I'm listening to is the forensic evidence, the true alleles, which I love. I find it incredibly interesting. But look, at the end of the day, this feels like a very good case for the state. And so what I'm listening to is you better have a really good defense lined up. Or otherwise, this is just going to be a slam dunk.
Right, Franz. I agree with everything you just said. For me, the one piece of evidence that jumped out was her pointing to the hat, that black ball cap that has Laken Riley's blood on it, the state says. And he's seen wearing the cap even after she was killed. So for me, that was one piece of evidence I hadn't heard about previously that I think, again, as you said, Franz, is adding to.
So if y'all don't know about the hat and you haven't watched the other one that I did this morning or watched any of this trial at all, the next day, Ibarra's brother, I guess, was wearing the hat that Ibarra used while he committed his crime. So they have digital photos of his brother wearing that hat, and they went and got, you know, they put him in to interview him, and they also found out that hat had some of Laken's blood on it. So obviously it had DNA. That is amazing, I think.
this mountain of evidence against this guy. Hit us up on social media. Let us know what's convincing you in this very persuasive opening statement. Franz, stand by, please. We're going to hit a break. We'll be right back with more Court TV Live on this Friday morning in the case over the murder of Laken Riley.
Buddy says I went to the wrong crowd, but I think I was the wrong crowd. Nobody in this world loves you like your parents.
You said, when did you close? I came with your internet party.
I couldn't get out of my head. I couldn't stop.
Which do you think you are? Sick and treatable or irredeemably mad?
Interview with a Killer. Season finale, Sunday, 8/7 Central. And don't miss the new season, coming in 2025, only on Court TV.
I might have to.
Hi, Mike.
On February 22nd, Jose Ibarra put on a black hat, a hoodie-style jacket, and some black kitchen-style disposable gloves. And he went hunting for females on the University of Georgia's campus.
Welcome back to Court TV Live. We're watching the case over the murder of UGA nursing student Laken Riley. The state delivering a powerful opening statement to start off this trial. Let's go back in together where we left off.
Also processed for DNA, prints, and for everything we got. But on the rocks in the tree, just Laken's DNA, Laken's blood on the rocks in the tree. They attempted at first, which is protocol, to do what's called YSTR DNA testing on Laken's fingernails. So both her left and her right hands were swabbed by the medical examiner in this case, and they were both sent to DNA for analysis. YSTR is a better fit for trying to separate male and females because only males have Y chromosomes. And so they attempted YSTR first, and they were successful. The problem with YSTR, and the officers did gather the DNA of Jose Ibarra, Diego Ibarra, and Argenis Ibarra. They are brothers, and blood brothers share the same paternal line, and they share the same YSTR profile, unless there's a genetic mutation. And what the lab found when they tested the fingernails of Laken Riley is that, first of all, the left hand, there's nothing. No DNA of any other person other than Laken. But on her right hand, there was male DNA. And for the YSTR testing that they tried first, Jose Ibarra could not be excluded as the donor of that YSTR profile, and neither could Argenis, because again, they're blood brothers, they share the same YSTR profile. But Diego could be excluded, and that's because Diego carries a genetic mutation that the lab was able to see, and he was able to be excluded as the donor of YSTR profile underneath Laken's nails. But after the YSTR was done, it was then sent to True Allele, along with a lot of other items. And when True Allele tested, and the data was sent into the True Allele program. It didn't test it, but when the data was sent into the True Allele program, True Allele excluded Argenis as the donor. True Allele excluded Diego, who had already been excluded by STR anyway, but True Allele matched Jose Ibarra to the DNA underneath Laken's right fingernails. To this likelihood ratio, which I have before the court here, 10 billion times more probable than a coincidental match. I will tell you the gloves that were tested, that's all just Laken's blood, the black gloves that were in the bushes. There's a straw that was tested, that is the defendant's blood. I want to talk to you about that a little later. And then the hat, the black Adidas hat, is also Laken's blood. And then the jacket also did contact swabs. So in addition to the blood on the jacket, they did contact swabs that were sent to True Allele. And again, it's the defendant and Laken on the jacket. But importantly on this jacket, also Laken's hairs that were wrapped around the button were sent to trace evidence. They are consistent with Laken Riley's hair. And of course, it's consistent with her long dark hair and all the microscopic analysis on it. Her DNA is on that jacket, so there's really no need to do DNA on the hair because her DNA is already on the jacket in the form of blood. But they looked microscopically at her hair and it's consistent with her hair. But the important thing they found about several of the hairs, I believe over 15 of them, is that they were forcibly removed from her head.
No way, man.
They did do a sexual assault kit on Laken, and several things were tested. But the bottom line is her entire sexual assault kit was negative for male DNA. Her clothing was looked at with AP, P30, you'll hear about that. There's no semen present. However, her underwear was sent to the trace evidence section as well, where they concluded that her underwear had been forcibly torn. So the medical examiner, Laken was sent to GBI headquarters in Atlanta or Decatur, where Dr. DeMarco conducted an autopsy on her the very next day after her murder. What the medical examiner found is that Laken had a complex depressed skull fracture on the left side of her head, and she had 8 other lacerations on the left side of her head, which literally look like holes. She had a small subarachnoid hemorrhage on the right side of her head, and she had multiple abrasions to her face, her neck, and her torso. She also had what's called petechia in both eyes, which is consistent with some form of asphyxia. And asphyxia can come in many forms, can be a drowning.
And we have learned about these words in the case of Ellen Greenberg, because she had some of the same type injuries to her head, and the petechia or whatever she was just talking about, that is basically the blood vessels in the eyeball bursting due to the extreme stress that they're under. And I mean, 8 lacerations. Man, this guy did a number on her.
But most importantly in this case, it can be a form of strangulation. It can be manual, it can be literature, it can be all kinds of things. But what the medical examiner said in this case is that Laken Riley died as a result of the effects of blunt force trauma to the head and asphyxia NOS, not otherwise specified. She can't really say if it was from chest compressions, maybe manual strangulation, but there was something going on in this struggle where this defendant deprived her brain of oxygen for long periods of time. And that was her cause and manner of death. But I want to talk to you about something that happened before, and it is count 10 of the indictment, and it is a peeping Tom. Shortly before 7 a.m., Hosea Barr is seen on the trail cam, and this is a version of the trail cam, or this is the angle you'll see. And you'll see an individual, and the state will be the first to tell you this video quality is not fantastic. But there's more than just this video. You'll see an individual wearing a dark hoodie, eventually a dark hat, black gloves, and holding a styrofoam cup. And UGA attempted to enhance this video. GBI Cyber attempted to enhance this video. This is about as good as it gets. You can see a bag. They've studied this video 1,000 times. You'll hear the things that they saw in looking at these videos. The male is seen on the trail cam exiting the defendant's apartment complex. That's how he gets onto the trail. It's further beyond outside the scope of this exact clip. But he gets on through a path from the defendant's apartment complex to this trail that leads onto campus. And this is Rogers Road, UGA Village housing for graduate students. And this is a bus stop that's used by students to take the bus to get to a class. At 7:01 a.m., this individual was seen at this door that you're going to see in the bottom or the middle of your screen. That's apartment 114. And in that apartment, 114, building S, lives a graduate student. She's an Indian national. Her name is Jaswi Sarathi, and she is here at the University of Georgia studying. This defendant is seen trying to open her door at 7 o'clock in the morning.
Yeah, that's another thing that was discussed at the very early parts of this hearing was this individual attempted to open this door at least 10 times. He was peeping around the side where there was no blinds. The blinds were up, and he was trying to look into the bathroom. As you can see right there, you can see him standing there. That trail cam has him perfectly right there. Man, that's an awesome camera. Look at the look on his face. Like, oh man, they got me. You definitely trying to break in there.
And there's about an hour's worth of video that was watched by UGA PD that between 7:01 a.m. and 7:57 a.m. on the 22nd day of February 2024, about 70 minutes before Laken Riley is murdered, this defendant goes to the door of apartment 114 6 times. Twice they can see on video that he to open her door. And at one point, you'll see in the video where he ducks down. And that is because at some point, the student inside heard him at her door and she pushes him at the door and says, "Excuse me." And she will testify to this court that when she said that, she's looking out her peephole, he ducks down. And you can actually see that on the video. And just here's a portion of her 911 call where she calls at 7:57.
Talking with some of my colleagues as we're watching this prosecutor deliver her open, which is excellent, by the way. And we're looking at this defendant's face. Doesn't he look surprised? Doesn't he have that look on his face like he's just stunned to hear all of this? That's the takeaway that some of us had. Let us know what your takeaways are. Also want to answer a great question from Julie on Twitter asking, why isn't this a death penalty case? Great question, Julie. It could have been. Many people believe it should have been. But the district attorney's office is ultimately who makes that decision. And this DA said she did not want to pursue the death penalty for Jose Ibarra. So that's where we are. It'll be life in prison if he is convicted. Now, we're going to hit a break. When we come back, we're going to get you back into the courtroom and hear the remainder of the state's open in the case over the murder of Laken Riley.
On the table? Y'all believe he should have gotten the death?
Hi,
With conviction? Hey, Nina.
Welcome back to Court TV Live. I'm Julie Grant. We're in the trial over the murder of beautiful Laken Riley, a 22-year-old University of Georgia nursing student killed brutally. She was out on a jog. Her skull beaten so badly, it was disfigured. Let's go back in now and hear more of the state's open.
Someone was trying to open the door, and then I said, "Excuse me," and then they just ran away, and then now they kept trying to look through my window. Okay, what's going on?
So she says she was in the shower and she heard her door jiggling. And she said that somebody was at her door. She says, "Excuse me," he ducks down and he tries to look through her back window and does look through her back window. This is her back window. This is the backside of Building S, and this is exactly how it was that morning. This is body cam footage of Officer Bridges, who's one of the officers that responded. Her blinds are open wide. They're open, not only open, but they're pulled up more than halfway. The right side is her living room. The left side window is her bedroom, wide open. Her blinds were that morning. She said that's how she kept it because it was kind of a dark place, and it was more comfortable for her to have some light in. And that's how her windows were. And she said when she turned around, she could see the person who she can't identify. And we the first to tell you she can't identify him. She didn't get a good look at his face. He had that hat over his face. He had a hood on. She describes the clothing, dark hat, dark jacket. Didn't get a look.
You know, I don't know about you guys, but I mean, natural light, kind of like right now, I have the window open, have the breeze blowing in. You know, we shouldn't have to explain why we have our blinds up, why we have our windows open, why we, have our doors cracked. We shouldn't have to explain that, male or female, People should respect people's lives and their privacy. It doesn't give people the right. It's almost like saying, since you had your window open right there and somebody started to crawl in, it was your fault for having that window open. No, ma'am. No, sir. It is not their right to just break and entering because you're giving them an entryway, you know? Thank you, Nina. I'm not sure what you're talking about, but thank you so much. What do y'all think about that? I mean, she's a college student. She had the right to have those blinds up if she wants, right? What do y'all think? What do y'all think about that? Give me some feedback.
His face, because when she looked through the peephole, he ducked down, but she could see him peeping into her window, looking into her window. So the FBI CAS team is a specialized team with federal government that analyzes digital evidence. And they were brought in this case to look at data from the defendant's phone, the victim's phone, cell phone records, all of these things. And some of the data that they got from the defendant's cell Samsung, one of them, which is 1B7, which you'll hear a lot from, is called Rubin data. And Rubin data is something that's collected by Samsung, and the FBI CAS team analyzed Rubin data, looked at the Rubin data in this case, and at the time of the peeping at Tasia Swee's apartment, the defendant's 1B7 phone is right over her.
So this is going to be probably what the same CAS report going to be in the Idaho 4 case. As you can tell, you know, there's a time, the minutes, and then it has the little dots, I guess, that show you exactly where the residence is, where the crime scene was, the associated address. So I'm just speculating here. I'm not for certain because I don't know that much about that, but this looks like a CAS report done on this crime.
House. And these are the digital points by the FBI. But also, there is a white styrofoam cup. In the video, you can see black gloves and the white styrofoam cup of the peeping. This cup was found by UGA PD as they were coming onto the trail.
So you remember he had what? When you saw him by the bus stop? What's the one thing that stuck out to you? A white styrofoam cup. And if they were doing a probable cause, I guarantee it almost that, you know, the PCA, I almost guarantee that styrofoam cup would be in the PCA.
To come to Laken Riley's scene. They thought it was unusual because there's no trash out there usually, and it's just sitting there. They collected the cup, and you can see in this next image, if you see where the retaining pond is in the middle of the screen, the cup is near there. So in between Building S, where Tasia Sweet lived, and in between where Laken Riley's body was found, was this white cup. That white cup was collected and sent to the crime lab at the GBI, and it is the defendant's DNA on the straw of that white cup in between the two crime scenes. So also out of his phone and out of his social media, the defendant.
This is totally off topic, but what would you do for a Klondike bar? Anyone?
When he woke up that morning, kind of a huge favor, and started taking pictures of himself. And here are the pictures that he took of himself and posted on Snap, and also can be found on his phone. And one was taken at 4:30 a.m. The second one was taken at 5:37 a.m. And you see in that one that he is wearing the black Adidas cap with the stickers on it, with the same jacket, with the hoodie. Also, he took pictures of himself.
What a piece of shit. He was taking selfies after killing this lady. Who does that? Who does that?
Wearing the same shirt that you see in the video of B32 and the bag that was never found that you see on the side of him in some of the videos taken on the day of Laken's murder. And also you can see from, again, D124 and D125, the day before the murder. He is in the evening before the murder, so this is the 20th at 9 p.m. He's wearing the same clothes. So in the end, Your Honor, That is a summary of the evidence that the case, summary of the evidence that the state has in this case. You will hear forensic evidence. You will hear digital evidence. You will see videos, all pointing to the same conclusion, that this defendant murdered Laken Riley, and he also peaked Tejaswi's apartment. At the close of all the evidence, we are going to ask that you find him guilty on every count of this indictment, because the state will be able to prove every bit of it. And we ask that with your verdict, the close of the evidence, that you bring justice to Laken, Tejaswi, and this community. Thank you.
What a great job with that opening stint. Sheila Ross, a special prosecutor brought in to handle this case, just delivering that open on behalf of the state of Georgia. You can tell this isn't her first rodeo. She knows her stuff, did an outstanding job. I want to bring in our legal analyst guest who served as a prosecutor. He does criminal defense work in the private sector now, Franz Borgard. Okay, Franz, talk to me here, please. I'm so many big revelations in this open. I mean, I am just astounded at how much evidence the state has to present against this guy. Tell me what you know as we're getting ready to hear from the defense.
So what I loved about her opening statement was it was very straightforward. It was very much, let me tell you how I'm going to connect the dots for you, Judge. She established that this guy is a hunter, that he was out hunting, that he was trying to prey on people, whether that was for deviant means or for maybe burglary. I'm listening and I'm like, oh, and look, this was already a bad case for the defense anyway. I love the fact that she has connected the dots with saying, look, everything points to one conclusion, right? The forensic evidence, the video. I think she did great. And what I really liked about her, Julie, was it's a judge trial. So she doesn't have to go over the top. She doesn't have to put on a performance and still be a very effective advocate. And she did a great job of that.
Yes, she sure did. She sure did, Franz. Okay, so if you're the defense team, what might you do here? Do you give an opening statement and follow that? Do you waive it, considering the fact that the defense has no burden and your client is cloaked in the presumption of innocence? What's the best way to handle this, Franz?
So I will tell you, Julie, that in 20 years, I've never waived an opening statement with a jury. However, this might be a case where I might waive it because it's a judge trial. Because standing up and saying, hey, I'm asking you to be patient, I'm asking you to listen to all the evidence, Judge, before you make a conclusion, that's kind of like looking at the judge saying, hey, I don't trust you. So why get up and say that? Now, maybe they have a theory of a case that vastly diverges from the state's. And if they need to plant that seed in the judge's brain, then that is the only benefit to me, in my mind, of them standing up and doing an opening. Because right now, there is no benefit with a judge trial. There's no benefit to them doing it.
Mm-hmm. Right, Franz. In different jurisdictions do things differently. I was telling my team, customarily, I practiced in Pennsylvania. If it was a bench trial, it was typical to waive opening statements, whether you were the state or in this case, so high profile, right? I fully expected the state to bring it, and she knocked it out of the park. Franz, one clarification I wanted to give to our viewers. I got a great question about how this case isn't being pursued as a death penalty case and why. And wanted to make a distinction here. So the district attorney, her name is Deborah Gonzalez. She is the one who made the final call that the state would not pursue it as a capital case and not seek the death penalty, even though they could have legally on the facts. Sheila Ross happens to just be the special advocate, special prosecutor brought in just to do this case. So I wanted to make that distinction for our viewers. Franz, when you've heard all of this evidence, I'm curious if you've been thinking about how this defendant really is getting a gift, even going into day number one, knowing that the stakes aren't as high as they could be penalty-wise.
True story.
Well, I think that's why we're seeing a bench trial. Is I think that he gains and loses nothing just sitting back and letting the process play itself out. He probably wasn't offered anything. And look, for the viewers, I will tell you, as a former prosecutor who indicted individuals on murder, I had cases that could have been capital cases, and I talked to victims. And ultimately, what I found was when I explained the distinctions between capital cases and how long they take in the process, and what happens when we don't pursue a capital case, and how you're not waiting decades to get a resolution and conclusion. I'll tell you, in my experience, many of the victims were like, no, we don't want to be living with this for the next 30 to 50 years. Pursue a non-capital route. Let's get a conviction. Let's put him away for life. And then we can have whatever closure we can gain out of it. And a lot of times I was surprised because the victims were the ones saying, hey, I don't want to pursue the death penalty if it's going to take that long. That said, he has been given a gift by not being in a capital case right now. And I suspect, again, that's why he's waived the jury. He's sitting back.
I agree too, man. I mean, that's a hell of a gift to not have to really fear that they're going to put you to death. I mean, even if you're found guilty, nobody wants to go away for the rest of their life. But, at least you still have the ability to communicate with your family and things like that. So I agree. I agree with what this prosecutor's saying.
Maybe his defense attorneys think maybe there's something that they can maybe do, but there's probably no offers, so he gains and loses nothing.
Mm-hmm. Right, Franz. Great insight you're sharing here. I mean, just taking everybody into what happens behind closed doors, those private conversations that you would have with the victim's family. And so we can assume that the district attorney, Deborah Gonzalez, did just that, and her office spoke with them at length. That's a very safe assumption to get the victim's wishes. But ultimately, as you know, Franz, the DA doesn't have to go with the victims in their position. The DA can choose what to do on their own without anyone else controlling that call. Here's what we'll do.
Let me ask a funny question here to the chat, all right? Those of you who've been watching this channel for a while, if I was ever a district attorney, I want you to put 1 if you believe that I would ever not call a death penalty. Like, I would never say, okay, this isn't a death penalty case. Press 2 if you believe that I would definitely call every murder case, possibly give them the death penalty. Or 3, you believe that I would be fair and just wait it, kind of, I don't know. That question sounded better in my head. You don't have to answer if you don't want to. Here we go.
We'll hit a break. When we come back, we're going to see the start of the defense opening statements in the case over the murder of nursing student Laken Riley.
This case clearly on the national forefront, brutal murder of this young woman, Laken Riley.
Investigators say she was beaten to death while going on a run.
This is a heartbreaking time for the university. We have a suspect in custody, Jose Antonio Rivera. He did not know her at all.
Such a violent, unprovoked act. Will there be justice for Laken Riley?
The murder of Laken Riley. Live coverage today. Only on Court TV.
Welcome back to Court TV Live. Back to the courtroom in Georgia we go, where it's time for the defense opening statements in the case over the murder of Laken Riley.
Judge, the evidence in this case is graphic and it's disturbing. What happened to Laken Riley is graphic and disturbing, and it is a tragedy. The loss of any life that young and apparently full of promise is a tragedy. And I'm sorry that the family is having to go through this and be here for the presentation of this evidence. People have used this case for their own personal gain, financial gain, political gain. And while this process has its place for testing evidence, it's very poorly suited to healing hearts and minds. So it's the evidence that we have to talk about. And the evidence in this case is very good that Laken Riley was murdered. The evidence that Jose Ibarra killed Laken Riley is circumstantial. The evidence that anyone had any intent or certainly committed any sexual assault is speculation. Most importantly, in this case, you'll hear no evidence that a sexual assault was committed. You'll hear nothing from the GBI, the FBI, UGAPD, ACCPD, that after looking at all of the evidence in this case, scouring for anything that could help prove this allegation in the state's indictment, that they found any biological evidence that would suggest that, any physical evidence that would suggest that. There's no.
Oh my God, I feel like I'm listening to the YouTube community right now. You know, guys, you will not hear any evidence that this person was even near the victim. Everything is circumstantial. I already don't like this defense attorney.
Injuries that are consistent with the sexual assault. And in this case, it's an effort to explain a tragedy, but it's not based on evidence. The evidence that Jose Ibarra killed anyone is circumstantial. The state's presentation in their opening had a lot of detail about information, again, that showed that this event happened. But upon a closer look at the evidence that links Mr. Ibarra to that event, it is lacking. You'll hear that his phone was in the area, and you'll hear that the cast team that ran the locations of this phone. And there's good evidence that the phone itself was in the area.
But it wasn't.
What you'll also hear, though, is that when they looked into this phone, when they did a close examination of who was using this phone, it wasn't just Jose Ibarra. It was other people in that apartment who were using this phone. And that comes through an investigation into the accounts that were used through this phone, and also from people who met.
Do you get what he's saying right there? Do you hear? I mean, because we hear this every day on YouTube, every single day. I'm sure right now somebody's online talking about it. But listen to what he just said. There were other people that could have been using that cell phone in the house. So that's just planting the seed, right? But he doesn't say anything about the cell phone being used during the time of the crime, at least not to this point. So when somebody is doing that, they are manipulating their words to get the biased result in which they're looking for. It's kind of like saying, well, he had the phone. Yeah, he never denied that. But there were other people that used the phone too. not just him. But how are you gonna overcome the latent fingerprint on her phone? This guy sounds very, very nervous to present this. Like, I know this dude's guilty. I'm gonna do my best, though.
Other people associated with this phone who had used the phone to message people. And so while the phone was there, that's true. It doesn't show that Mr. Ibarra was there. And you'll hear that Mr. Ibarra's fingerprint was on Laken Riley's phone. But you also hear that he was wearing gloves, supposedly. And that this hole that was supposedly in the gloves that they found would not have left that mark. You'll hear that someone in that video, in the so-called dumpster video.
That's a fair point there. That's actually a really good point the defense attorney is making about how the fingerprint, if the suspect was wearing gloves. Look, this defense attorney's got a tough job to do, but somebody's got to do it, and he is trying. We're going to hear more from the defense in minutes, and you're going to hear from the state's first witness, Laken Riley's roommate. We'll be right back.
In his hunt, he encountered 22-year-old Laken Riley on her morning jog. And when Laken Riley refused to be his rape victim, he bashed her skull in with a rock repeatedly. That is what this case is all about.
This is Court TV Live. I'm Julia Janae. Thank you for being with us. I'm in this morning for Ted Rowlands. We are following several trials in Georgia today. We're in Athens, Georgia, where we're bringing you a bench trial for defendant Jose Ibarra. The prosecution in that case says that Ibarra beat Laken Riley, a nursing student, to death with a rock and then strangled her back in February. We'll get you back into court in just a moment for those opening statements. We're also watching the courtroom in Canton, Georgia. It's day one of the defense case in the murder trial for Chloe Driver. The defense claims she was criminally insane when she used a kitchen knife to stab her own one-year-old daughter to death. The first defense witness is a forensic psychologist who evaluated this young mother.
And what did you learn about Miss Driver's background?
I learned that she has sort of an unstable early childhood, that her family moved around and she felt like they were kind of cold, but that she also left the family several times. She left and moved in with boys. She even left the state and moved in with a boy. She had some suicidal ideation early on, some self-injurious behavior.
Okay, I'm going to turn that one off, and I'm going to get to the other part of the video that I want to show. I don't get how people kill little babies. I don't get that. I don't get that. Mom's a whack-a-mole, that's why, huh? Or wackos. Okay, gotcha. Whack-a-mole, wacko, same difference, right? But anyway, what do y'all think about this case so far? I mean, it's been around. Some people did, broadcast it when it first happened. It's not like nobody did it. But also at the same time, there is you heard the defense. They're talking about, there's going to be substantial evidence you're going to hear. And even though blah, 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 there's no way this could have been this and there's no way that could have been that. It's like the defense lawyer to me is like a person that he can hear the truth, but he's going to debate you anyways. He's going to try to find an outlet that makes his argument more feasible than the evidence that you have pointing towards your client. Well, let's go ahead and hear what this man had to say. This is the judge right here.
It's the best we can do. I'm going to start by swearing the interpreters, and then I'll go over some other things. Who we got? Two?
She's my second interpreter. She's already qualified with the commission and she will assist directly to the authorities if I have to do it.
Okay. All right. If you'll both stand and raise your right hand, you swear that you will truthfully and accurately translate English to Spanish and Spanish to English to the best of your ability, so help you God.
I do your honor, Madam Lewis, master license legal interpreter to the state of Florida.
Thank you. Are you all where you need to be and your equipment's operating? All right, good, good.
She's also from Venezuela, who's facilitating Canolingo from that country. I do know the language. She also is.
Very well. I will just leave it to you. If you notice something is malfunctioning or not happening, let me know.
Absolutely.
All right. And of course, Mr. Ibarra as well.
We sure will, Judge. Thank you.
I call the case of State of Georgia versus Jose Antonio Ibarra. Superior Court of Athens, Clark County, SU 24 CR 0323. Charged with 10 counts. 1 count of malice murder, 3 counts felony murder, 1 count kidnapping with bodily injury, 1 count aggravated assault with intent to rape, 1 count aggravated battery, 1 count obstruction or hindering a person making an emergency telephone call, 1 count tampering with evidence, 1 count peeping Tom.
Get his ass.
Has entered a plea of not guilty. Is the state ready?
Issue has been joined and the state of Georgia is ready to proceed.
Defense ready?
Yes, Your Honor.
All right. Anything we need to take up preliminarily? I believe there was a motion yesterday. Is there an order with that, or I need to address that orally? If I missed something?
We do have an order, Your Honor. It was just emailed, not to the court, so we will email to the court right now. I will tell the court, for the purposes of restarting, I do not anticipate any of those types of photos that would be subject of the order to appear until after lunch. So we will email, Your Honor, the proposed order and counsel our proposed order, and that could be something we can take up on a morning break. Thank you, Your Honor.
Ms. Beck?
Yes, Your Honor, there is an outstanding motion to reconsider motion to suppress. It is just based on one statement of fact that we believe is inaccurate as to how the defense obtained the records from the cell phone. If Your Honor wishes to wait until the agent is recalled for the trial, I think the testimony will clear it up. But to the extent that that one fact in any way affected Your Honor's ruling, we would just point out that is still outstanding.
All right. We'll take that up, and you're welcome to remind me
Yes, sir.
about that.
Oh, and Your Honor, it was brought to my attention by co-counsel that apparently during our live stream of the proceedings on Tuesday, the cameras and live stream that went out continued to record after Your Honor left the bench and the attorney discussing matters. So I guess I would just ask that Your Honor instruct the media to stop live streaming when Your Honor is not on the bench.
Okay. And that is the instruction when I'm not on the bench or otherwise call recess, but may be sitting here. That's a signal to stop streaming. Thank you.
Judge, if I just may, I don't know what's going on with this camera here. It is very close to us. It is very intrusive to our ability to communicate. And done, I will caution the court that that's there. And we would ask that the media be instructed not to record any interaction between any of Mr. Ibarra's attorneys and himself to protect attorney-client privilege. If that's what's going on here, I think that's problematic.
Could y'all defend a murderer, especially if you knew the evidence like this defense attorney knows it? Or would you be able to be objective?
It's live stream, but there's a delay in the live stream. And they have been instructed to not publish interactions between the defendant and the attorneys. And also, I understand that the microphones will be recording. It will not be picking up conversations that between you all as well, as long as it's done in, tones that could normally be picked up. So, sure. And I don't mind being reminded if somebody sees something that's not appropriate. We're trying to get this done. Anything?
Let's do a roll call. Type in your state. Those of you that are in the chat, put in your state. Let's do a roll call.
Very well. I'm not going to remove it at this time. I mean, there was a discussion about that, and it was decided that rather than moving around it would be less obtrusive than moving around cameras. So that's what we have. Do you want to be heard further? Ms. Ross?
No, sir. I'm sure counsel for the defense will notify the court if they feel that camera is intrusive.
I'll revisit it anytime I need to. All right. State ready with the opening statement?
Yes, sir.
Okay, this is the wrong one. I didn't mean to share the same one we've already done. Hold on a second. I thought this was a different one. Okay, yeah, I wanted to get to the witness statements here, so let's get right here. Sorry about that. Where'd everybody go? There's only like 3 people in here now. Me, Rondi, and somebody else. I didn't mean to run you off by asking where you are from. Here we go.
Sure. Sure.
This is the defense attorney. I didn't really hear a good one earlier, so I wanted to play this one.
The evidence in this case is graphic and it's disturbing. What happened to Laken Riley is graphic and disturbing, and it is a tragedy. The loss of any life that young and apparently full of promise is a tragedy. And I'm sorry that the family is having to go through this and be here for the presentation of this evidence. People have used this case for their own personal gain, financial gain, political gain. And while this process has its place for testing evidence. It's very poorly suited to healing hearts and minds. So it's evidence that we have to talk about. And the evidence in this case is very good that Laken Riley was murdered. The evidence that Jose Ibarra killed Laken Riley is circumstantial. The evidence that anyone had any intent or certainly committed any sexual assault is speculation. Most importantly, in this case, you'll hear no evidence that a sexual assault was committed. Hear nothing from the GBI, the FBI, UGAPD, ACCPD, that after looking at all of the evidence in this case, scouring for anything that could help prove this allegation in the state's indictment, that they found any biological evidence that would suggest that, any physical evidence that would suggest that. There's no injuries that are consistent with a sexual assault. And in this case, it's an effort to explain a tragedy, but it's not based on evidence. The evidence that Jose Ibarra killed anyone is circumstantial. The state's presentation in their opening had a lot of detail about information, again, that showed that this event happened. But upon a closer look at the evidence that links Mr. Ibarra to that event, it is lacking. You'll hear that his phone was in the area, and you'll hear that the cast team that ran the locations of this phone. And there is good evidence that the phone itself was in the area.
Hold on a second. I know this is going to sound funny, but I looked at that lady right there at the bottom in the pink. It looks like she had an electric shaver on her head, on her face. Does anyone know what that is? Like, what the purpose of using that is? Like, is she talking into it and it's, putting out the words? I know they used to have the stenographers or whatever they were called. They used to type the stuff, but I don't know if that's the new technology there. Does anybody know that? I was like, man, is she shaving her face? What's up? I know I'm a goofball.
What you'll also hear, though, is that when they looked into this phone, when they did a close examination of who was using this phone, it wasn't just Jose Ibarra. It was other people in that apartment who were using this phone. And that comes through an investigation into the accounts that were used through this phone, and also from people who met other people associated with this phone who had used the phone to message people. And so while the phone was there, that's true. It doesn't show that Mr. Ibarra was there. And you'll hear that Mr. Ibarra's fingerprint was on Laken Riley's phone. But you also hear that he was wearing gloves, supposedly. And that this hole that was supposedly in the gloves that they found would not have left that mark. You'll hear that someone in that video in the so-called dumpster video was wearing an Adidas hat. That's true. When they find that hat, and specifically the hat that was tested in this case, it was worn by Diego Ibarra, not Jose Ibarra, Diego Ibarra. And you'll also hear, and
Thank
the
you,
state
Kelly.
will ask you to consider different types of forensic evidence and to suspend your understanding of how that evidence is evaluated. Because while they will say that Mr. Ibarra's DNA was present at the scene, what they'll tell you is that without this software that we can't test, this proprietary software used by the GBI, without that, their expert wouldn't have been able to say whose DNA it was. She wouldn't have been qualified to testify about whose DNA that is. So they have to use a machine. And they're going to ask you to trust that machine where the human being isn't good enough. But with this fingerprint, they're going to ask you to trust a person because a machine isn't good enough. When they run those fingerprints through the database of fingerprints where they know Mr. Ibarra's fingerprint is, it doesn't come up. And so while a machine is good enough in one situation to try to convict Mr. Ibarra, it's not good enough in another. And it's this kind of gymnastics that it will take to tell the story with this circumstantial evidence. We waived a jury trial in this case with the hope and trust that despite the nature of this evidence, that you could come to a verdict that was not just a way of easing this family's suffering. It was based on an impartial and honest assessment of the evidence in this case. If that happens and the presumption of innocence is respected, there should not be enough evidence to convince you beyond a reasonable doubt that Mr. Ibarra is guilty of the crimes charged.
That wasn't bad. That wasn't bad.
You may call your first witness.
State calls Lily Steiner.
I hope the Idaho 4 case trial goes like this smoothly. Not a bunch of, theatrics. Right there, it looks like the People's Court. You may call in your next one. Here we have Jane Doe from California.
Where's this push going?
Does he look nervous to y'all? Does he look uninterested? Does he look like, like many people say, well, they don't look like a killer? Does he look like a killer to y'all? Like a killer has a specific look, but does he look like a killer? Would you be scared of him if you're a female?
Pull the Elmo. Thank you. Would you raise your right hand, please, ma'am? Do you swear or affirm the testimony you will give today in the matter of the state of Georgia versus Jose Ibarra will be the truth, the whole truth, and nothing but the truth, self you got? Okay, please take a seat. Spell your first and last name for Madam Court Reporter, please.
My name is Lily Steiner, Lillysteiner.
How old are you?
I'm 22 years old.
And where do you live? Not your exact address, but what part of town?
Currently,
Yes.
I live in Canton, Georgia.
And what are you doing right now?
I'm working as a medical assistant.
Did you go to the University of Georgia?
I did.
Did you graduate?
I did.
When did you graduate?
Graduated in May 2024. This year.
While you were at the University of Georgia, where did you live and who did you live with?
My address was 1686 Village Avenue Extension, Athens, Georgia 30605. And I had 3 roommates, Conley Huth, Sophia Magana, and Laken Riley.
Most definitely.
How long did the 4 of y'all live in that house together?
Connolly lived with me for 3 years, and then Sophia and Laken moved in. We lived in that house for 2 years. I lived with Laken at the time of her death for a little over a year and a half.
How would you describe your relationship with Laken?
We were roommates, but the term roommates is an overgeneralization of our relationship. We, our house was like a little family, and we called each other our family. We did everything together. We had family dinners, family TV nights and movie nights. Laken brought a sense of joy to all of our lives that has been missing ever since.
May I approach the witness, Your Honor? Yes. Penny, what's been marked for identification purposes of states Exhibit 1. Do you recognize the person in States 1?
I do.
Who is it?
Laken Riley.
And does it fairly and accurately depict Laken as she appeared in life?
Yes.
Statement moved to admit States Exhibit 1, request permission to publish. No objection.
It's admitted, and you may.
So how old was Laken?
She was 22.
Where did she go to school?
At the time, she was going to Augusta College of Nursing, which had an Athens location.
What was she studying there?
Nursing.
Prior to attending Augusta College, had she attended the UGA?
Yes.
Okay. How long was she at UGA?
She was at UGA for 3 years before that.
Did you and Laken and your other roommates share each other's location?
We did.
Tell the court how you all did that.
So there's an app called Find My iPhone, Find My Friends, and you can request to have other people's locations, share your location with other people. So we did that with a lot of our friends.
Tell the court, where were you on February 22nd?
I went a few different places. That morning I was at our house, and then I ran a few errands, ended up back at our house, ran another errand, went back to our house.
Did you see Laken that morning?
I did not.
Okay. What time did you leave your house?
Around 9:30, I believe.
Okay. And when you left your house to go out, was Laken there or not there?
She was not there.
At some point, did you become aware that people were looking for Laken?
So I kind of had concerns of my own. When I left the house the first time, I wanted to go get coffee with Laken. I knew Laken was the only one who may have been home. Sophia was taking an exam and Connolly had class. And so I knew Laken might have been home. I went downstairs and I didn't see her sitting at her usual spot at the kitchen table. So I checked her location to see where she was. And I saw that she was on a run at on a trail that she typically ran.
May I approach the witness, Your Honor? Yes. I'm handing you what's been marked for identification purposes of States Exhibit 2. Do you recognize States 2?
I do.
What is States 2?
This is a screenshot from the app Find My Friends of Laken's location.
And is that how it appeared when you checked it on the morning of February 22nd of 2024?
Yes.
State would to admit States Exhibit 2. No objection.
Two's admitted.
And may I publish? Publishing States Exhibit 2. Could you tell the court what we're looking at here? Explain this to us. What is this?
Sure. So the LR is the initials of Laken Riley. You can see that at the bottom. And underneath her name is a rough just address, I guess, of where she was at. And then underneath that, it says now. This is the exact time of when her location, the way that it updated, it would say now. So that was her location at that exact time.
And is that what you saw when you first checked it?
Yes.
And where is that location? And is your house in here as well? And other people? We see other initials. CH, MC, whatever.
Yes. So CH is Connolly Huth. That is my roommate. And so her location right there is at our house. And then MC, that is one of my other friends who lived further down the street.
And LR was Laken Riley?
Yes.
And where is that location that you saw her? Are you familiar with that location?
Roughly, yes.
Yeah. And when you checked it, what about the first time you checked it? Approximately what time?
It was about 9:30 from what I remember.
So did you again check it again?
Yes. So when I got home from my first set of errands, and I saw that Laken still wasn't home. That wasn't unusual because it was only about an hour after I checked her first location. So I thought maybe she was just still on a run. Checked it a second time around 10:45, I believe. That's a rough estimate. And I saw that it was in the same location. That did raise some concerns. So I texted Laken and just was checking in on her, and then addressing Connolly in a group message. I said, she's been in the woods a while.
Did you have a cell phone service that day?
So that day there was an AT&T service outage. So I was not, I did not have service if I was not connected to the Wi-Fi at my house. So if I left the house, I was not to communicate or receive any communication.
So where were you home then? Approximately what time did you get home when you realized that she had not left the woods?
That was about 10:45. And then I ended up leaving the house again because I still wasn't, I just thought she was still on a run and there was maybe she was on the phone or something.
And then what time did you return again?
I would say roughly 11:30. I'm a little less familiar with what exact time.
You know, if this shows anything, it shows the innocence of our thought pattern. You know what I mean? You notice like she's not jumping to conclusions, like the worst case scenario. She's not saying, oh my God, I thought something was really wrong with Laken. You know, she wasn't saying any of this. So she's 22. Laken was around the same age as the Idaho 4 kids, almost, you know. So that gives you an insight as far as how individuals in that age range, how their thinking persists. We're texting, we're looking at our locations, you know, they're at the house, they're here, they're there. You're not really going to freak out. And then as things escalate and cultivate, that's whenever your mind starts going a little to other places. So the fact that you instantly don't go to the worst case scenario, it means that you have a stable mindset where you understand that there are possible scenarios that might not be the worst case, because her Find My iPhone was not moving. The location was stuck in one place. So that means that iPhone was stationary and Laken was stationary. So she thought, man, she's been there for a while. What the hell's going on? So this is a good friend. You're going to hear a lot of good people. They really cared for this woman.
Time that was.
And when you got home at 11:30, was there anyone else home?
Yes. So I immediately pulled in and I saw Sophia standing outside with her dog. And I got out of the car and she just immediately said, can we go look for Laken? Yeah.
And did y'all do so?
We did.
And what did y'all do?
So Sophia was a little bit more familiar with the trail. We walked down using her knowledge of the path that Laken would take on a run. And then when we got a little bit closer, we were using the Find My Friends app to kind of go directly to where her location was until we were standing kind of right around it.
When you were at the location where you felt that Laken was showing on her phone, did you see Laken?
We did not.
Did you see anything that you think may have belonged to Laken?
So when we were walking, Sophia noticed a lone AirPod that was sitting on the trail, kind of right around where her location was, and she picked it up, kind of assuming that it was Laken's.
All right, now I'll ask Sophia about that. At some point, did you all return home?
We did.
Okay, when you got home, what did you do?
It wasn't shortly after that we got home that I called 911, or not 911, excuse me, the UGA Police Department.
May I approach the witness? What's been marked for identification purposes as State's Exhibit 3? Do you recognize State's 3?
I do.
What is it?
It is the phone call that I made to the police.
And is it a fair and accurate recording of your 911 call that you made on February 22nd, 2024 at approximately 12:05 p.m.?
It is.
When you reported Laken missing?
It is.
State moved to admit State's Exhibit 3, request permission to publish. No objection.
Te van a chingar, vato. Why'd you do that, bro? Of everything you could have done.
Your Honor, did we have to toggle back over so that you could hear it? I don't know the system like that.
Yes,
We do.
Laptop.
Yes, sir.
I'm not sure, but we'll see.
Yes, sir. Because I know it's playing, but I can't hear it.
Is that on HDMI? I don't know.
Yes, sir.
Okay.
12:05 seconds, February 22, 2024.
Mercy, police, this is Jed.
Hi, we're calling because our roommate went out for a run at 9. He usually runs like through with Carrick behind grad housing, and we haven't heard from her. And we all just got like service back, so we don't think it has anything to do with the outage. To go look to where her last location was, and all we found was an AirPod.
Okay. Hold on one second for me.
Okay.
You said last seen near the iron fields?
It's like behind the iron field, so we live near like grad housing, like building 8, and so it's the woods behind there.
Okay, have you tried calling her since you just got service back?
Yes, we've been here. Her family doesn't have AT&T, so the one with the power outage, so they've had service the whole time, and her calls have been ringing through. We're just not getting answers.
Okay, so where are you at right now?
I'm going to stop Season 3 at 1 minute in. Is somebody else also talking?
Yes. So I was
Tell the
having
court.
trouble explaining kind of where Laken's location was, just because I'm super familiar with that area. So Sophia Magana, my roommate, took my phone.
Okay, are y'all together when you're making this call?
Yes.
At our house on Millers Avenue Extension.
Okay, are you able to come? Hold on, let's see. Can you come, do you know where the intramural field parking deck is?
Yeah, we can go there.
Okay, can you go there and meet the officers? What's your name?
My name's Sophia Magana.
And what's your friend's name?
The one, her name's Laken Riley.
12:07:43 seconds.
2nd, February 22, 2024.
What is your phone number?
The one that I'm calling you from is 678-756-0513.
What's your phone number?
Okay, I'm gonna ask you, do you remember Laken's phone number off the top of your?
See, they do ask you for your phone number. Good grief.
head?
Kind of, but yeah.
Are you about to say it to 911?
Yes.
And is the number that you gave, 911, was that Laken's cell phone number?
Yes.
That we're about to hear?
Yes.
All right, thank you.
Let me look. 779.
Do you know if she has class or anything at this point?
She has a class at 1, so that's it's her nursing. She conducts a nursing school and she does not miss class. Well, 08:42, 2nd, February 22, 2024.
How did you get her last known location? Was it from her phone?
Yes, it was updating, so that's why we're a little confused. We didn't see her phone up anywhere when we went. But she hasn't moved for almost 3.5 hours now.
When you call her, does it go straight to voicemail or does it just keep ringing?
It keeps ringing. I'm on my way to the iron fields now.
Okay, that's fine. How long ago was it that you last called her?
I mean, like 5 minutes. 12:09:56, 2nd, February 22, 2024.
Okay. So what kind of vehicle are you going to be in so the officers know who to look for?
Okay, I'm gonna stop it right here for today. I probably will pick up this again shortly. I can't do hour after hour after hour just to be on, you know what I mean? Like they're going over the phone calls from the roommates, but what we've heard from the prosecution and we've heard from the defense attorneys in the opening statement, so it gives you a pretty clear case of what they're about to defend or argue against, and to see if the individual really is guilty of committing this crime. You know, it's hard for me to go on a defensive side no matter what. I mean, not that I'm closed minded and think that everyone's guilty of what they do, but, based on my years of experience and, working in various fields, it's hard to go against what you've been taught. You know what I mean? Like you have trainings and you have continuing education and you have all this stuff that you get constantly re-upped with the latest things, and it's hard to really go against what the training and the investigation says. So I'm enjoying this trial. I'm enjoying this case. I hope that you come back and spend some time with me among some of the other chatters. Hopefully they get involved in this case, because you know what? Sometimes you need a break from that other case. These two are kind of alike if you look in different variations. I mean, because they're talking about the same type stuff that the Idaho case is going to talk about. So if anything, it will give you some knowledge of how to understand the wording and all that entails. Well, I'm going to ask you guys, can you dig it? Can you dig it? If you can't dig it, you need to get yourself a bigger shovel. I am feeling a little better. That's why I'm going to go take a nap to continue this process. Maestro, cue that music.